I'm back. Hello, that was quick. Hello, 𝗟𝗶𝗸𝗲. Hello, 𝗝cie𝗵𝗄𝐿. Just us hanging out in here. Small little light crowd. That's okay. We're going to be covering Stephan Sterns. Hello, welcome back. I literally just did a live on Carmelo Anthony case and Austin Metcalf case. So make sure you check that out. Thank you for being there. For those of you who were. I have not watched Stephan Sterns' new hearing, testifying. We're fun. We are fun. We don't need anybody else. We're fun all alone by ourselves. No. Have you guys watched this? Vomit in my mouth when I think of this man, but I've not watched this, so I need to get caught up. So let's get started. Stephan Sterns back in court, hearing to suppress evidence, cell phone evidence, and speaks in court. So I'm shook a little bit that we're hearing from him. Let me pull up the screen. Here we go. Hello, Curtis. Okay, let me get this played. By the way, this is the only stream I could find with it, so we are going to have to fast forward through some parts when they do like their commercials. Look at them.
Any cross requesting?
Yeah, sure.
Thank you, Ms. Fennell.
Can I have just a moment?
Yes.
This is wild. He needs to. Stephan Sterns is another one that I can't.
Mr. Sterns,
Justice for 𝗏𝗏𝗄𝐻.
you briefly discussed having a conversation or being interviewed by Detective Tagler and Detective Acasta on February 27th. Is that correct? Of last year?
That's correct.
And pursuant to the questions you were just asked, you had indicated that you did not consent to the search of your cell phone.
I consented only to them looking at the Google Maps and checking to see if I was logged into Google in the first place.
Did you have the opportunity to see what law enforcement was doing on your cell phone?
No, as Acasta was still talking to me, Tagler walked away and began searching all the things that I did not consent to.
Isn't it true that she actually handed your phone back to you?
Briefly, when she told me to input my PIN because it had locked itself.
Sorry, this is
and
his mom is a huge part of that.
Detective Tagler actually mentioned looking at your history, which you okayed, correct?
I think there's something there.
Your Honor, can we approach?
Yeah, come on up.
I can't
hear the discussion there. At the center of this is the question of consent and whether Stephan Sterns consented to the search of his phone. We apologize for the audio quality there. Obviously, very overmodulated. Not anything that we can do on our end here. But it looks like they may be working to try to address some of those issues. But let's go ahead and keep listening in.
The question was, in fact, your cell phone.
Easy ones.
I don't have any other questions.
Thank you. Can you redirect? Thank you. Argument state.
Well, the hearing is going to continue. It appears that Stephan Sterns' testimony has come to an end. Very brief there on the direct and also on the cross-examination as they discuss whether the evidence collected from his phone and Google account can be used going forward. We're going to continue with her courtroom where a suppression hearing is going on in the case against Stephan Sterns. This is the case where he is charged with several dozen counts of sexual battery, images, a number of things relating to 13-year-old Maddie Soto. He is also charged with her murder. That is a separate case. But this suppression hearing to block evidence that was obtained from his cell phone, from his Google accounts, that the defense
can't
says
believe that.
was improperly obtained, that illegally
Improperly
searched and
obtained. He had
seized.
like
And so we heard
17,000
from Stephan
pictures.
Sterns himself earlier in the show saying that he did not give consent. And so now we are hearing from a number of investigators on this case. This is a detective with the Orange County Sheriff's Office talking about her interactions with Stephan Sterns. Let's go ahead and listen in.
Yes.
And then almost around noontime.
Yes.
Thank you. Overruled as to leading. I've got a question. The times that you just gave were for identifications of the tag through the LPR system. Overruled.
And then the afternoon times of going in and out of St. Cloud, do you recall what those were?
I do not.
I can't believe he's been
Did
talking.
you document those times and locations in your narrative that you drafted for the
Yes.
case? Would looking at your narrative assist in helping you remember the specific times that the vehicle was traveling in and out of St. Cloud?
Yes.
Your Honor, I'm approaching the witness for the record with Detective Tagler's 11-page narrative.
Thank you. I'm looking at page 4.
Does page 4 help refresh your memory as to the times that the vehicle was picked up on the Tagger you're going in and out of St. Cloud?
Yes.
What times was it traveling towards or into St. Cloud?
This is eastbound on US 192 and Pecan Street at 13:05 hours, and westbound on US 192 and Academy Drive at 14:23 hours.
And you were equipped with this information at the time that you responded and met with Mr. Sterns?
Yes.
Were you aware as to who the last person to have seen Madeline Soto alive or have seen her was?
Yes.
Who?
Stephan Sterns?
Is that consistent throughout a lot of law enforcement interviews that were conducted?
Yes.
After you get this information and your task is to assist in the investigation, what's the next thing that you do?
Detective Acosta and I respond to Kissimmee to their residence, and we meet with Detective Hunt.
When you say their residence, are you referring to Miss Jennifer Soto and Madeline Soto's residence?
Yes.
That would be on the Santa Maria Drive.
Yes.
When you get to the address, who is there?
Detective Hunt is there. There's other patrol deputies on scene, and Jennifer and Stephan.
Is there law enforcement conversing with either Jennifer Soto or Stephan Sterns?
Not at the time.
Who is the first person that you speak with?
Detective Hunt.
Does Detective Hunt relay information that he obtained during an interview with the defendant to you?
Yes.
What information do you recall receiving prior to your interaction with the defendant?
He stated that he had spoken to Stephan and Jennifer, and to his knowledge, Madeline had not made it to school, that Stephan had dropped her off near the school, and that they were supposed to go to McDonald's, but they didn't. And then he watched her walk towards the direction of the school, and then he went home.
Did you receive at that time any information about the sleeping arrangements on February 25th of 2024, the night before?
Yes, Detective Hunt told me that Madeline and Stephan had slept together in room number 4 because Jennifer needed to get more rest that morning.
Equipped with this information, did you come into contact with Stephan Sterns?
Yes.
How did you know who was Stephan Sterns and how to find him in the area?
Detective Hunt pointed him out.
Was your
Nice to
encounter
put
with
like
Mr.
faces on
Sterns
people who we've heard about in
Yes.
these police reports.
As a detective, what is your uniform, for lack of a better word, when you are at work? What do you wear?
Professional attire, like I'm dressed right now.
You're not in a police uniform when you make contact with Mr. Sterns?
I am not.
How about Detective Lewis Acasta?
Same, not in uniform.
Does anybody approach Mr. Sterns with you and Detective Acasta?
No.
Where is Mr. Sterns when you approach him?
We're all standing behind his vehicle.
When you say his vehicle, who are you talking about?
The Lincoln?
So the defendant's Lincoln.
Yes.
And at this point in time, is the defendant handcuffed?
He's not.
Is the defendant free to leave?
Yes.
How is his demeanor, meaning the defendant's demeanor when you're interacting with him?
He was very emotionless, but otherwise able to answer every question that we had for him.
Did the defendant, seem groggy, confused, unable
He's
to
disgusting.
communicate?
He did not.
Did the defendant respond appropriately to questions that you were asking?
He did.
Would you classify his behavior towards you as cooperative?
Yes.
Can you explain to the court, I know that you indicated that you're all standing in the back of Mr. Sterns' vehicle, but can you explain to the court where everybody is positioned?
Yes. I was standing on the left side of the trunk. Stephan Sterns was standing directly next to me. We were basically shoulder to shoulder. And Detective Acasta was standing closer to the wheel well on the right side and the corner of the car.
Was Mr. Sterns' path of travel impeded by either of you?
It was not.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns ever communicate with you either verbally or by body language or physically a desire to end the communication with you?
He did not.
Questioning continues inside an Osceola County courtroom as they talk with Detective Myra Tagler, an investigator with the Orange County Sheriff's Office. You see Stephan Sterns there sitting at the defendant's table, leaning over, speaking with his attorney, who's a public defender, representing him in these cases. He is charged in 2 separate cases, including sexual battery and the death of 13-year-old Maddie Soto. We're going to take a break here on Florida Live. We are continuing to monitor developments inside the courtroom. We're going to step aside for a couple of minutes, and we'll be right back.
I'm going to fast forward through a lot of this. Break stuff.
Afternoon edition of Florida Live. If you're watching on
Other law enforcement.
Thank you. Redirect.
I sleep better when my daughter is with me. How could you send Maddie to sleep with him? Look at him, how nasty he
Defense
is.
mentioned that there were other law enforcement
What?
personnel that were
That'll never make
at the
sense to me.
apartment complex.
She needs to be arrested.
During your interactions with
It's always
Mr.
been my
Sterns,
opinion.
who was in the immediate area?
Just myself and Detective Acasta. Everybody was kind of just hanging out in the area.
I don't have any other questions.
Detective Tagler, I've got a question. When you initially interacted with Mr. Sterns, you indicated that you are going to take a photo of his history. Is that correct?
Yes.
Did you take a photo of his history?
Yes.
Was that on your agency cell phone?
Yes.
Any follow-up questions based on that question? State.
No, Your Honor.
Defense. No, thank you. Detective, step down.
Yes, Your Honor.
Detective Tagler, excuse.
Yes, Your Honor.
Detective Tagler,
Thank
step
you.
down. Thank you.
Yes, Your Honor. Detective Lewis Acasta.
I can't believe him. What he did to Maddie is horrifying for so long. I can't comprehend it. Jen Soto needs to be locked up too.
Raise your right hand, please, for.
Do you solemnly swear or affirm the testimony you are about to enter into this case to be the whole truth and nothing but the truth and all be God?
Yes.
Will you please say your first and last name and spell both for the record?
Lewis Acasta, Louisacosta.
How are you employed?
Orange County Sheriff's Office as a detective.
How
This
long have
is
you been with the
cute.
sheriff's office?
5 years.
In February of 2024, what was your assignment?
I was a
Someone give Liz
detective with the
my
Orange County Sheriff's Office Sex Crimes Unit.
How long had you been in that unit at that time?
Approximately 6 months.
Are you still assigned to that unit?
Yes.
How did you
ACW,
become involved in the investigation of missing juvenile Madeline Soto?
I was the secondary on-call detective at the time, and I assisted Detective Tagler with the investigation, going over to the command post. We assisted our missing persons unit at that time.
What information did you learn at the command post?
We learned that Maddie Soto had been missing for a little over 24 hours. She was 13 years old. We knew that the last person who had seen her was Mr. Sterns. Just, that basic information.
Okay. Did you also get information regarding LPR tag reader hits on Mr. Sterns' LinkedIn?
Yes,
And you also got the timing of those tag reader hits?
yes,
Did you respond along with Detective Tagler to 4012 Santa Maria?
I'll probably be covering Maddie case
Yes.
next week again.
And did you learn any additional information prior to speaking with Mr. Sterns at that address?
yes. Prior, we were briefed of Detective Hunt, who's the initial primary detective assigned, just some additional details. For example, that she slept in the same bed as Mr. Sterns, things like that.
Yuck.
Did you assist in the interview of Mr. Sterns that was conducted by Detective Tagler at approximately 7:16 in the evening?
Yes,
And this would be on February 27th of 2024.
yes, correct.
Where did this interview take place?
It took place in the parking lot of their of the apartment complex near the residence, Maddie's residence.
Who was in the immediate vicinity as this interview was being conducted?
It was Mr. Sterns, myself, and Detective Tagler in the immediate vicinity.
Where would you say the next closest law enforcement official was?
At least 25 yards away.
Were all of the law enforcement officials within view of where you were?
The ones that were in the parking lot could see the general vicinity we were at.
How many law enforcement officials would you say were in the parking lot area of where the interview was conducted?
Maybe 10, fewer than 10.
And were these law enforcement officers engaged in tasks, sitting in vehicle, like what was going on?
Yes, just kind of setting up a perimeter around the area, making sure media didn't get too close, just kind of standing by for tasks.
Scene security?
Scene security.
Did any of these other law enforcement officials have contact besides you, Detective Tagler, and Detective Hunt earlier in the day with Mr. Sterns while you were there?
While we were there? No.
Where were you and Detective Tagler and the defendant standing during this encounter?
We were behind the trunk of a vehicle. I can't recall the specific vehicle.
Was Mr. Sterns' ability to move about freely inhibited by either of you?
It was not.
How about any other law enforcement officer that was there?
No.
Were there any law enforcement vehicles prohibiting other vehicles from leaving the area or anything like that?
No.
What was Mr. Sterns' demeanor during your encounter with him?
Kind of very just matter of fact.
Would you classify his conversation with you as cooperative?
Yes.
What were you and Detective Tagler wearing? Not obviously specifics of what you were wearing, but were you in plain clothes?
We were, yes, plain clothes.
Did either of you ever remove your firearms from their holsters?
No.
Did either of you remove any handcuffs, taser, any type of weapon?
No.
Were there any threats of arrest made?
No.
Was Mr. Sterns free to leave?
Yes.
Did Mr. Sterns, based upon your encounter with him, seem to respond appropriately to questions asked?
In what way?
If you asked a question, did Mr. Sterns respond in a way that was?
Yes.
Did you have any difficulty communicating with Mr. Sterns?
No.
Did Mr. Sterns fall asleep or ask to be excused from the interview?
No.
At some point, did Detective Tagler ask Mr. Sterns to look at his cell phone?
Yes.
Do you recall where the cell phone was during this initial interaction?
When she asked to view his phone, he said yes, and it was within eyesight of him. We were right next to him.
Who had the phone when Detective Tagler asked to look at some of the stuff on stuff?
Mr. Sterns had the phone, and then he gave the phone to Detective Tagler after she asked him. He said yes.
After the reset?
Did Mr. Sterns
Not
have to
before.
do anything to the phone prior to giving it to Detective Tagler?
He input his passcode to get it.
Where was the defendant and Detective Tagler standing?
Jen Soto needs to
while
face
Detective
charges
Tagler was viewing the content of the cell phone?
for neglect
They were standing shoulder to shoulder next to each other.
and being an accomplice.
Were you asking questions at that point?
Yes.
Were you able to see the content of Mr. Sterns' phone?
At some point.
Oh,
Were you
wow.
standing next to where Detective
That was
Tagler
really
and
hard
Mr.
for
Sterns
him.
were standing, or somewhere else?
Yes, next to both of them.
The detective, so he's probably used to it, but it's terrible. Poor Maddie.
Was Mr. Sterns facing the general area of where his cell phone was being displayed from?
Yes.
There is a point in the interview where Detective Tagler steps away. Prior to stepping away, what is done with the cell phone?
She gives the cell phone back to Mr. Sterns.
Do you continue to have a conversation with Mr. Sterns?
Yes.
At any point in time, does Mr. Sterns discuss the content of the cell phone or Detective Tagler's looking through them?
No, I don't.
At some point, does Detective Tagler come back?
Yes.
And is the cell phone brought
Yes,
out?
Natasha, we're back.
Yes.
At this
Oh,
point,
yes.
who had the
The
cell
heck?
Still Mr. Stearns.
Girl.
And Detective Tagler asked
What?
for Mr. Stearns to unlock the cell phone again. Does he do so?
Yes.
That's wild.
Does he have to enter the passcode again?
Yes.
I don't think I've ever done that in my life, girl.
Are the circumstances surrounding this interaction the same as what you described previously as far as location and people involved, the defendant's ability to leave?
Yes.
At the time that that interview concludes, Detective Tagler keeps Mr.
I wonder if he'll
Stearns,
get the death
correct?
penalty.
Yes.
What information did you
They decided to keep it,
have
right?
together
Or was that Brian Koberger? I'm getting them confused.
about the Madeline Soto investigation?
So aside from what we had before, that she had been missing for over 24 hours, he was the last person to see.
I guess I don't really have a
any
one to do that.
inconsistencies surrounding the time frame that he stated. He dropped her off and other things. And then the tag readers and information that we had about his movement.
Had the defendant been straightforward
I had to sneeze and I got my drink.
with you and Detective Tagler regarding his movements?
No.
I should be more clear. His movements the morning of February 26, 2024.
He told us certain movements that didn't correlate to the information that we had.
How does Jen seriously not know for 5 years or so what is going on? Yuck. And he was abusing her daughter and then having sex with her? Gross.
Did you
Yuck, 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 Jen Soto. Yuck.
confirm with the defendant that he regularly used his cell phone to get places, look up addresses, get store hours, directions, things like that?
Yes, I believe that was brought up.
Were you aware that there was very limited location data and mapping location data that was in his phone? Check that.
Yes.
Were you aware also of information that was located in Madeline Soto's cell phone as far as communications between her and the defendant?
Yes.
What information did you have about that?
They communicated extensively, including very late at night.
Were you
I believe
also present
his
with
mother knew,
Detective
too.
Tagler at the conclusion of this interview?
My opinion only.
Between the second interview that was conducted at 12:15 a.m.?
Yes.
What were you guys doing in that interim time?
So in the interim, we were reviewing surveillance video from the apartment complex to corroborate the times that he came back into the apartment complex.
Did you learn any new information when you did that?
Yes. One of the surveillance videos that we saw, it appeared that there was somebody either asleep, passed out, or not awake on the inside the vehicle.
What exactly did you have information as to the last clothing items that Madeline Soto was reported to wear?
Yes.
Was the individual in the driver's seat or passenger seat is what you just described?
Yes, wearing the same
Were they in the driver's seat or passenger seat?
passenger seat. Front passenger seat.
What about their appearance makes you believe that they were not awake?
Slumped over, kind of leaning back. Just did not appear to be awake.
And you observed this video between the first and second interviews.
Correct.
And the individual that you just described, was that consistent with the characteristics that you were knowledgeable about Madeline Soto?
Yes.
The second interview, were you present at 12:16 a.m. when Detective Tagler again spoke with the defendant?
Yes.
And it was during this interaction where
Who the hell is Jen Soto?
there was a brief conversation. Did you have
anyone
a brief
seen her
conversation
anywhere?
with the defendant about what was seen in Madeline Soto's phone?
She's
Yes.
really stayed quiet throughout all of this. It's kind of
What
creepy.
did the defendant attempt to explain that to you?
Yes.
What did he say?
He initially said she thought of him as a father figure. Then he immediately said she thinks of him as a father figure. Just said that it was a father figure-like relationship.
And you also were present when Detective Tagler then speaks about downloading the cell phone.
Yes.
Can you kind of elaborate on that encounter as far as
oh. Wait, wait, wait,
Had calls from
I'm gonna go like too far back.
she explained
Sorry, that was a
would be
glitch.
taking the phone, be getting it back whenever the phone download was complete.
did Mr. Sterns limit the download of the cell phone in any way?
No.
Did the defendant refuse to give consent to download the phone?
No.
Did the defendant willingly provide the passcode to his phone?
Yeah.
Yes.
And all of this is recorded, right?
Yes.
At what point do you recall learning that the phone was factory reset?
I believe during the first interview, while Detective Tagler was looking through the phone, she noticed that the call logs, he only had calls from that day, the date of the interview, so from February 27th. So she asked him about it, why he only had calls from that date. He said he had accidentally factory reset his phone the day prior, attempting to
We all know the factory reset's a huge lie.
just some sort of
You can't accidentally do that.
update.
They ask you like a gazillion times if you're sure.
As a law enforcement officer, have you had the ability to seize or collect cell phones belonging to individuals during investigation?
Yes.
When a cell phone is taken, are you aware, or do you put the cell phone in airplane mode or secured in any way?
Yes, it's placed on airplane mode.
Why?
To prevent it from being remotely reset or anything being deleted remotely.
So you're aware of that possibility?
Yes.
No, I don't think so.
No further questions.
Cross-examination.
Good afternoon, Detective.
Good afternoon.
So the interactions between you and Stephan Sterns, that was audio recorded, right?
Yes.
Not video recorded?
No.
And it's my understanding that you have an agency-issued cell phone, right?
Yes.
And that has the ability to document photos as well as videos?
Yes.
Okay. Did you do any of that documentation, the photos and videos, while you were speaking with Mr. Sterns?
I did not.
When you said you arrived on scene, you said there was about 10 other either deputies or officers on scene?
Roughly spread around the parking lot area.
Okay. And you said that they were securing a perimeter, right?
Correct.
Making sure that media wasn't coming in and out of the apartment complex, right?
Yes.
Okay. So that means that there were going to be officers at the main entrance area of the complex?
Yes.
Okay. And they would have been staying right there the entire time, making sure who's coming and going, right?
Yes.
Okay. And then at this point, it sounds like the apartment was getting secured to search, right?
Yes.
Thank you, Emmanuel.
So does that mean putting up crime scene tape and everything?
I can't recall about the time of the interviews at crime scene.
Okay. Some point I got a crime scene tape.
Yes.
Okay. And when you say that the officers, deputies, whatever, were in the parking lot, were they
Whatever.
just clumped up in one group together or across the entirety of the parking lot?
So some of the detectives were
Oh, Mary,
kind of
you
in
made it
one
back.
group,
Yay.
and then uniform
Thank you,
patrol
Mary. I
were
appreciate you.
kind of in the perimeter.
I'm glad you're back. We've missed you.
Well, Steve asked you if you ever removed your firearm. I just want to clarify, you had your firearm on you, right?
Yes.
You're in plain clothes at this point, right?
Yes.
So is your firearm just chilling right there on your holster? Or-
Yeah. On my hip. Yep.
Yeah. So it's visible.
Yes.
This is the new pig
And you
vomit
said that while you're questioning,
hearing.
well, you and
Thank you, Mary. Appreciate it.
Detective Tagler were questioning Mr. Sterns, you're both standing by a vehicle, right?
Yes.
I don't know whose it is, but it was a vehicle, right?
Yes.
Okay. And at this point, Tagler's questioning him, you're questioning him, he's in the middle of you two, right?
I can't recall where he was between both of us.
Okay. But you're all towards, it sounds like the back of the vehicle?
Yes.
Okay. And you had stated that while Tagler's taking a look at the phone, you're close enough to see.
We are live, but
Yes.
we're hearing
So
this
you
from
can
like a
actually see
couple of
what's
days.
happening on screen.
Yes.
Okay. So it's not like when we're saying
But yeah, we're
standing
live.
on the vehicle, somebody's over by the front of the car over here and somebody's all the way at the trunk of the car over here. You're all grouped up together, right?
Hey, Stubbs.
Now,
Yeah. I have another
it was
one
during
after
that
this.
first interview that you learned that the phone was factory reset somehow, right?
Yes.
And
This is
when
Sterns hearing.
y'all were leaving the scene, it sounds like Tagler gave you the phone?
She gave it to Mr. Sterns.
Okay. At the entirety of both first interview, second interview, everything. When you're taking the phone to the sheriff's.
Oh, sorry. Yes. Yes. Yes.
Gotcha. So you had the phone at this point?
Yes.
Before you had come into possession of the phone to take it back to the sheriff's office, it sounds like it was in Tagler's car?
I'm not sure where it was.
But between the first interview and the second interview.
I like this detective because he's not like condescending.
It sounds like there's about.
Like some can be up on a stand.
Yes, somewhere around there.
Somewhere around there. And at that point, you said that you went to the management to kind of take a look at the video surveillance, right?
Yes.
Okay. It'll take 4 hours to go through all the video surveillance?
Not all just at the video surveillance. We were also debriefing kind of next steps, things like that.
Right.
Discussing the case.
So when you're saying debriefing, like, right, just you and Tagler, or are you talking other?
Other people that
I don't know.
Okay, so where does that happen?
in the management area.
Okay. So at
I
that
don't know when
point,
the
while you're debriefing,
Hearing, but I thought the
roughly how
call
many law enforcement
was
personnel are there?
scheduled for July
I don't recall the number.
Can you remember anybody that was
with
there?
two. There was going to be
Detective
two
Tagler,
pre-trial
myself,
hearings. I thought in July.
Direct supervisors, so maybe a corporal.
Yeah, it is.
sergeant.
I like it too.
So at least 2 other people present?
Yes.
I like putting
And it's
the,
at this point.
especially
that's
ones
where
that
you're
have
all
been going on
talking
for a while.
supervisors, right?
Yes.
At that point, it sounds like one of the supervisors was like, hey, we need to go get that cell phone, right?
But yeah, I believe it came up.
Am I wrong about that, child, or no? I thought that's what
And
it
during
was.
that conversation, did anybody ever mention,
Yeah,
hey, let's
I
get
thought I
the
read
warrants
a
down
couple
with
of
that?
days ago.
Not to my recollection.
Okay. After you take the phone to the sheriff's office, do you ever interact with the phone again?
No.
Okay, so you just hand it off to the forensics guys and you're done?
Yes.
And did you ever ask Mr. Sterns if he could download the entirety of his phone?
I did that conversation was had with Ms. Secretary Tagler.
And did you ever seek a warrant to download the phone?
I did not.
Did you
I
ever?
can't believe that they're trying to
track the
suppress
warrant
this
of anything?
information.
I did not.
It's like so important to the case.
Between the first interview and the second interview, you had never,
No.
neither you nor
Oh,
Tagler
bro.
ever gave the phone back to Mr. Sterns, right?
Correct.
You held on to it the entire time.
Yes.
Sterns. He looks
Did you
older.
conduct any interviews between the first and second interview with Mr. Sterns?
Yes.
Who else did you interview?
Jennifer Soto.
So that was also during that 4-hour period?
Yes.
No further questions.
Detective, between the first and second interview, around the 4 hour, at the conclusion of the first interview, did you observe anyone direct Mr. Sterns that he could not leave?
No.
And when you returned after 4 hours, Mr. Sterns was where?
He was in the same parking lot area.
Any follow-up questions, Dave?
I bet he was coloring his hair before gel now. Yeah,
Next.
During that time span between the two interviews, did anybody?
I
tell him
definitely see that. He's disgusting.
I don't recall that.
Thanks. And the detective step down.
Justice for Maddie.
Thank you, detective.
Lock up Jen Soto.
Additional witnesses are up.
Yes, Your Honor. Sergeant Darko. 𝐿𝐴.
Yeah, he's. Yeah. Yeah, Jen Soto needs to.
Please raise your right hand at this point.
Do you solemnly swear or
Where is
affirm
she?
that you are about to enter into this case
Hiding away in a hospital at home. We have literally not heard one peep from her since this case started, which is wild because that's the mom. It's her mother. She has known all of this 8 years. Absolutely.
Darko
That a part of it, yep.
𝐷ARKO STAMENIC.
I always thought that about Jen.
I'm currently a sergeant at the Orange County Sheriff's Office Digital Forensics Squad
How long have you been a member of the forensic squad?
since June of 2023.
They need to get her for something, whether it's neglect, being complicit, being involved, lying to the police, goes on news media, lies about everything. Like, she needs to be held accountable.
What type of training have you undergone to perform some of your duties in the?
How can you call, right?
So going back to college,
Yeah, she wasn't a
at
very
the
good
University of
Maddie.
Central Florida, I minored in IT. After that, I went to 𝗟𝗶𝗸𝗲 school where I became a 𝗟𝗵𝗸𝗲 certified
Oh.
operator as well as 𝗟𝗵𝗸𝗲
Celebrate.
certified physical
Can read
analyst.
case.
Those are two certifications that we have to use some of the tools that we
Covering
use.
that one next.
And then I also went to the International Association of Computer Investigative Specialists, where I obtained my certified computer forensic examiner certification as well.
Did you download any phones as part of the investigation into the disappearance of Madeline Soto?
Yes, I did.
Did you first download a phone that belonged to Madeline Soto?
Yes.
When did you begin that cell phone download?
It was shortly after 2 p.m. on February 27th.
Do you recall about what time?
I've never seen a
that
tear out of Jen.
download was
No.
completed and viewable?
She
Believe
lied in the
around
2
5
interviews she
o'clock
did, so
in the afternoon.
That's a couple hours.
A couple hours, right?
Okay.
it's gross.
So, can you explain how an extraction is done with the equipment that you used in this particular case?
Yes, so we have a tool that we use to extract the data. So we connect the phone to a tool. The tool's able to extract the data, bypass any whatever passwords there are on the phone, if there are any, extract the data from the phone. Then we take that data and we have another tool that parses that data, basically makes it readable by a human.
Yay, I'm glad to hear that, Mary.
The time that it takes to extract
sexy or
the
sick?
data from a phone variable upon the specific phone and maybe the data that's included in the phone?
Yes, absolutely.
Specifically with Madeline Soto's phone download, after it was completed, did you have the ability to share the data with
That's
other
true.
law enforcement officials that were working that same investigation?
Yeah,
Yes,
just
I did.
for Maddie.
How did you do that?
So we have a tool where we're able to upload that data that we extracted, and we're able to share it in the cloud to detectives, so detectives out in the field
How can you pick that disgusting thing over your daughter?
can view it.
Your
Did
innocent,
you do that
kind
with Madeline Soto's cell phone the same day? that
Yes.
you-
daughter. You guys never lie. Good to
Yes,
see
I
you.
did. I'm sorry.
Did you also complete the cell phone download for the defendant, Mr. Sterns' phone in this case?
Yes, I did.
Do you recall when you received Mr. Sterns' cell phone?
Yes, so shortly before 3 a.m. on February 28th.
Did you wait at Orange County Sheriff's Office Central Communications Building?
I did, yes,
So you waited for Detective Acasta to come from Kissimmee?
correct.
What did you do upon receipt of the phone?
I
I
like
began
Detective
extracting
Okay.
the phone,
Don't come through.
and then I went home.
She chose the monster and not him.
2:28.
Yes.
So what specifically did you do with the phone to begin the extraction?
Connected to a tool and follow the procedures on the tool to begin the extracting the data.
Was the cell phone itself secured in any way prior to your receipt of it to secure the data in the phone?
Yes, it was placed in airplane mode.
And after
I totally
you
didn't know they did that. The whole airplane mode
plugged the phone
thing.
into the equipment that you utilized, you said you went home.
Correct.
Did the cell phone download process during your period of absence?
Yes.
Did you secure the room that this was being completed?
Yes.
And what time did you arrive back?
I believe it was about 8 a.m.
Did you check on the progress of the phone download when you arrived back?
Yes,
Was it completed?
it was.
Can you explain, for this particular phone, I believe it was a Samsung type phone?
Correct.
How do you factory reset it?
Yes, so you have to go into the settings of the phone. I believe this, the next button says general settings. So you have to go into there. Once you go into there, you have to scroll to a button that says factory reset. Once you press the factory reset button, it asks you a couple of times if you're sure. It makes you type in your PIN code to the phone again to verify that it's you to to reset the password, to reset the phone, I'm sorry.
So it's multiple steps to actually accomplish a factory reset.
It is, yes.
Is this
We already know that.
possible to do if you're simply updating the operating system on that particular phone?
No, the button to update is in a completely different part of the settings.
When this specific phone is factory reset and the user goes back on to, again, utilize the phone, is there any information that is populated on the phone from prior uses?
Yes, so when you're resetting the phone, it asks you to log back into your Google account, and then information that you have backed up on Google will repopulate onto the phone.
If the phone is placed in airplane mode, does that prohibit the phone from resyncing with a Google account?
Yes, it does.
If items
Yeah, it's
are
ridiculous,
subsequently
Tipsy.
deleted from a Google account and the phone is in airplane mode, do the items remain on the phone if they've been backed?
They do.
If a
Ice,
phone
right.
is factory reset, is it still possible to obtain location data and other information from before the factory reset?
It is, yes.
How do you do that?
Different ways. So for example, the pictures, if pictures are backed up, if the pictures are pulled again, the pictures may have location data associated with them. So things of that sort.
Hi, 𝗿𝗏, good to see you. This case is so sick, so sick.
Thank you.
He's so bro. Like, what more do they need? Why does he get a? Now everyone gets a trial, but what in the court of justice or whatever.
When you're doing those forensic
But
you said that there's a tool that
17,000 pictures of abusing Maddie.
Correct.
I don't get
It's
it.
not just downloading the information that's immediately accessible to the user. It's downloading
I think arrest them all, his
Correct.
parents and
When
Jen
it's
Soto.
doing that download, does it do a bit-by-bit copy of the entirety of that?
The mom knew. The mom knew. She even in that last in the phone calls when she said like, yeah, I was sending. Why were you in bed with her? Like, why were you, sleeping with her? Pics of him abusing Maddie. Wasn't that how many they found? It was like, or was it? Oh no, it was 60,000 pictures, something like that. When did he factory reset? The night that Maddie was called in for a missing child. Yeah. That is beyond messed up. It was like, how many? Let me look it up. Because I have like a ton of them, but it was like something terabytes, I thought. He had a lot. He had a lot of content of him abusing her. I can't remember the exact number. Disgusting, I know.
No, it depends on the phone.
Okay. And with this particular phone, did it?
This particular phone, it did a
I think
full
both
file
of them knew, the mother
extraction,
and the
so it's
grandma.
not a bit-by-bit copy.
Yeah, it was a crazy amount.
When it does that, though,
Hey,
when the
TS,
phone's
good to see
factory
you.
reset, you can still pull that information off the phone, even though it's not immediately accessible to the user.
Like, I'm sorry, what?
The information prior to the factory.
He has
Oh,
60
No,
um,
not necessarily, no.
Okay,
S
not
abuse
necessarily, but
charges.
In this case, you were able to pull information prior to the factory reset, right?
I think he was putting that on the dark web. I don't know if I'm gonna get flagged for saying that. I know YouTube's weird about stuff. I think he was selling those on the dark web for sure.
Yes.
Okay.
Yes.
And when it comes to pulling that information, how long can that information stick around on the phone?
So in this case, the information had repopulated after the reset. So it was on the cloud and then it repopulated on the phone.
And I feel like
after.
the mom
Do you know at what time?
has a weird relationship
It
with
was,
Stephan Sterns.
I believe, around 2 a.m.
And
after the reset. I believe the
Something
reset
feels
was around
very
midnight,
off there.
and over the next couple of hours, the phone repopulated.
You saying 2 a.m.?
I don't know.
Downloaded it or before?
A part of me was
Would've
like
been when
thinking that, you know, psychologically thinking, was his mother in love with him and not a child way? Do you know what I'm saying? You catching my drift? Yeah, it was Telegram and Discord. I think it was both. Yeah, but he was on Telegram the night that I think he unalived her. Yuck.
Phone was reset, and I don't want to speculate.
Yeah, so many women sacrifice.
And
I don't know. I just think the dynamic is very odd.
When it comes to a phone being factory reset,
That's just my
do you
opinion,
want
allegedly.
Any kind of timeline to make
My
sure
opinion
that
only.
your data-
Not really, no.
Okay,
She's
so that's
too
not a concern
off
to,
with him
law enforcement, right?
and
No.
protects him
So once it's factory reset, it's factory reset, doesn't matter.
Right.
and babies him.
Of course.
Or she definitely knew about, obviously, when she paid the neighbor off, so she knew her son had issues.
When you did the download of the song, anybody give you a
What
warning
made Stephan
on the side?
Sterns become who he is?
No.
Again, the nature versus nature, nurture? Did he just become evil?
Witness, step down.
Where did he recognize that kind of abuse
So just
to go and do that to someone else? My question.
Your Honor.
I'm gonna take a 5-minute recess.
Why was it so easy for him to do that?
Court is in a 5-minute recess.
He was familiar with it? Okay. Ew. Yeah, they do need to be locked up. What did she pay the neighbor off about? So Stephan Sterns was like peeping. No, it wasn't a neighbor, it was a roommate. Stephan Sterns had a roommate and he was like videotaping the roommate in the shower. And the mom paid the roommate off or something like that. He was like being like a peeping Tom in the shower. I think it happened like twice. Well, that we know of. That like the mother was involved, allegedly. Is it really allegedly though? Because the roommate talked about it on an interview. We'll probably cover it because we're going to deep dive it. We've already started to deep dive it, but we'll probably play that video. But yeah, no, the interview, the roommate spoke up about it. Ew. Ew. I just think about like him like not leaving Maddie alone, and I'm like, I feel like Maddie was experiencing Stockholm syndrome, like already. You know what I mean? Like, I cannot believe, you know what I mean? Like when I say Stockholm syndrome, like did she essentially start to think that, because it had been happening since she was so young. I bet she started to think it was like normal. Oh my God, I can't. I'm officially nauseous now. Yeah. The roommate shared a folder on the laptop and allegedly found CSAM as well. That's right, Krista. I can't. I will never comprehend it. Nasty is right. Let me fast forward to this part. I want to hear him testify. He's really gross. Why did Jen Soto like him again? Can someone explain? Better yet, let's hear from you, Jen Soto.
How
Will the real Jen Soto please stand up? Where is she? Probably, and the gift giving is all part of it too. Yuck.
when it comes to the burden for attacking the warrant itself, the primary basis for the state's argument is it's on four corners of the warrant affidavit.
Groomed. Mm-hmm.
So when it comes to the verdict itself, we would be arguing that it's satisfied at least for the arguments we heard at this point, considering that challenge.
Oh, well, hey, Jen A. Jen
So,
A.
did you anticipate presenting witnesses? or
Where's
evidence
Jen A,
for that
girl?
motion?
No.
So you were just going to present argument.
Yes, sir. Based on, right now we have the chain of how the
Let me-
warrant came about. And then.
Why is this even a hearing? They're not going to suppress shite.
Okay. So you're going to make argument as to the sufficiency of the warrant itself and technical defects?
Yes.
I can't wait if this is what he ends up doing,
That's
Cindy.
been adduced in
Miss Pig, no Mother of the Year award there.
support the probable cause or the lack of.
No Mother of the Year. She gets worst Mother
Say
of
any
the
clarity?
last.
Florida Rule
Well,
Criminal Procedure 3.190
I bet I can name off some other ones too, but she's definitely up in the last few centuries.
states
If he has a brain, he would sing about a bird. I can't wait if he does.
on its merits, the defense
Throw her under the bus.
shall present evidence supporting the defendant's position, and the state may offer rebuttal evidence that the defense's burden is to show that.
I'm sure Jen's out of the mental hospital now. It's been a while. She's hiding out.
The state to be required to present rebuttal evidence.
She's scared.
The affidavit is not before your honor.
He's just trying to save his own life. I will think
So as
he
to
throw.
sufficiency,
Yeah,
Of the warrant,
I think that too. I think he'll throw Jen under the bus when they realize that the 𝗟𝗶𝗸𝗲 is not getting removed. They can't find a way around it. Then he's gonna throw Jen A under the bus, and he's gonna be like, "Nope, we had a full-blown threesome, or something crazy." You know what I mean? There has to be proof somewhere. She nasty too. Super
what
McNasty.
evidence does the court have to make some determinations as to the sufficiency? of
Okay,
the
well,
warrant?
please don't do that in your neighborhood. Thank
Talking
you.
about the technical defects that are alleged in the motion.
Yes, Your Honor.
You know what?
At this point, it's actually part of the court file, so we would ask them not to judicial notice of this.
It's not part of the court file. Search warrants are not part of the court file.
Not
I've seen
McNasty.
some affirmative presentation of evidence
McNasty.
regarding the argument.
Do you know McJimmy? I do. He's
Some
McJimmy.
kind of technical deficiency
For
that
sure. I'm into
makes the
McJimmy.
search warrant of the.
Not this
activity
McPig nasty up here either. Gross. Get him off the
to
screen, please.
determinations
My eyeballs.
that- let me ask
My
you,
soul.
Requiring the defense to recall.
Yes, all allegedly,
witnesses
and in
that
my
just
opinion.
Testified, or if they can find their argument to information that was elicited.
Do I think Jen Nasty is a
on
McNasty?
cross. Does that
Yes.
satisfy? their-
My opinion.
Shall we go through that entire exercise again? Sure.
Allegedly, yeah. Allegedly, she's a big nasty. Oh, look at this. I don't know. I feel like Stephan Sterns' mother knew and Jen Soto's mother knew slightly, or they had to have an idea. The body cam footage of the grandmother at the work is way too telling to me. Something felt really off there. Ew, and he just wants his little dragons and what was it, like a
Your
Digimon?
Honor, the state is of the position that the defense's burden regarding challenging the search warrant has not been met. The state's not going to require the defense to recall the witnesses that have previously testified. However,
Yeah, I think how Jen's mother acts at the police at the work when they go and find them there, like she doesn't even comfort Jen. Like if my mom knew that my sister's kids were missing, she would be like comforting my sister and her whatever boyfriend or whatever. Like her mother is just like, I ain't even gonna go over there and hug her. Like it was just very much cold, and I feel like either she really didn't like Jen or she knew something was up.
there is no
And Maddie
information
reiterated that to her that evening
about
when they go to visit her at her
at
workplace.
this point. So the state's position is that they have not.
His
met
little
their burden
ew.
pursuant to the rules of criminal procedure
All his
to
toys.
shift to require the
Yes.
state to present rebuttal evidence.
They all seemed strange. They all seem like weirdos. Like, how mentally sick do you have to be like, yeah, go sleep with my daughter and you know something's going on?
Additional testimony.
Either you're okay with it or you're literally mentally sick. Your brain needs to be dissected so we can learn more about the humans. You know what I mean? Like, that's not normal.
Satisfies their burden. Or
I'm just
not.
saying.
Is the state anticipating presenting additional evidence?
The state has an additional witness should the court find that the defense has met their burden to challenge the warrant.
Like, he would text Maddie more than Jen Soto. Like, that's weird.
Defense makes argument that.
Yeah, the Woody Allen love story, that gives it away too.
Google warrant
That was
relied on illegally
wow.
obtained evidence, and that there was no attenuation or intervening circumstances that urged.
Yeah, the no bedroom.
It's her testimony from the investigator.
He looks nasty as steps, definitely.
That challenges the legality of
No,
the search and
we
seizure.
won't touch him.
Appears to be what the
I agree, Krista.
challenge on the warrant refers to, and that it is.
That's probably why he abused Maddie.
Searches.
Because other than Jen,
As far as the application failing.
no
to
one wanted
establish
him in his purple
probable cause,
dragons.
does not have the application.
You know what I mean?
The legal
I
statement,
actually don't have anything against
probable
purple
cause
dragons,
of
but
search warrants was
when they involved a major
kind of
predator,
whether it was a digital search warrant, the argument that it fails to establish a sufficient nexus between the Google account and criminal activity. I don't have the affidavit, so that would be a difficult finding for the court to make. The reliance on boilerplate language.
Jen failed Maddie, or his third nip.
I have no evidence to support that argument.
Natasha,
The temporal scope.
why did you have to remind me of that?
We have no evidence to support that argument, and peculiarity for digital searches. without additional
Throw up.
information, the court will find, that
Ew.
there's no evidence to support that argument. As to the evidence supporting the argument.
He like wanted Maddie to like the third nip?
The search warrant
Yuck.
is invalid.
He's a
based on
total
lack of
predator.
probable
What?
cause, reliance-
Them?
Sorry, based on reliance on legally obtained evidence, no intervening circumstances urging that taint.
Cracking up over here.
Invalid as fruit of legal search and seizure. I think that evidence has been reduced in combination with the first two motions. So as to those issues, the court will find.
I'm having a Modelo right now.
Record evidence
I
that
have
supports that
one
argument.
best boy.
Given the hour at this point,
I'm gonna get some before the next live. We're doing the Melly after dark tonight. Ew.
These three motions were set together. and-
Oh my god, I'm sorry, y'all are super funny.
Given the court's ruling, the state will call it.
You guys want to kiss his third nip? Like, gross.
You're watching
I didn't know
Fox
that. Okay,
35 News Plus, streaming on Fox Local.
Well, good afternoon.
Oh, okay. Wait. Let me. They do like these breaks during the hearing because they're like, "What did you just say, Melly?"
Court Tuesday morning. And this hearing came before today's scheduled suppression hearing that
I
Garrett
don't
was
want to
just
be the
mentioning,
next
in which Sterns and his attorney was looking
Y'all
to
gotta know
delay
about it.
citing
He's
newly
so-
obtained
Ew!
confidential information according to court records.
And
Now, the
smells
defense
bad.
was
Yeah, he
hoping to
smells
prevent jurors from being able
terrible.
to see that evidence from Sterns' phone, his Google
Stinky.
account, which they claim was unlawfully
Don't
obtained,
shower.
though prosecutors argue he gave consent.
He
However, at the
smells
hearing
like
yesterday, the judge
run
denied
with it.
Sterns' request for the delay, which is why you were seeing.
Wait, where's the court
We've heard it
hearing?
all. Just
Wait, I
wait,
want to. We
because
better
Myra is gonna
see
prove-
him testifying in this.
And I put it
If not,
on
I need
the
to find it.
The emergency.
Did they already do? We haven't seen it. We haven't missed it in this stream.
You're watching Fox 35 News Plus,
Yeah, that
streaming on Fox Local.
Welcome back into Fox 35 News Plus. Let me get you
I know how
back
they are.
inside.
By motion basis, that'd be helpful.
In the meantime, I know the defense cited some of the case law from their motion. I
Ew,
did
ew,
have the
ew.
opportunity to review most of the case law. There is one case that I had difficulty finding, so if the defense has a correct site or a copy of the case, I would appreciate it. I could not find 𝐵ELLE_State, the site that you cite. I could not locate. It's on page 7 of your seizure motion. As far as the defense's argument, the defense relies on place, and place is actually distinguishable. Your Honor, I did provide a court exhibit A. I also have a flash drive. I prepared all of the state's case law from the motion, and I put it on a USB organized by motion so that it was easy to be accessible rather than providing a bunch of paper copies. The state's relying on all the case law presented in the motion, and I made it a court exhibit so that it's in the record for appellate purposes. The first thing that we need to do, Your Honor, is decide
Myra, I don't think they show him testifying.
whether or not, or what type of seizure this was. I would agree with defense that this was a warrantless seizure of the defendant's cell phone. A warrantless seizure of the defendant's cell phone is permissible when you have probable cause plus a warrant exception. In this case, the state's relying on exigent circumstances. The probable cause, there's numerous case law that defines probable cause. The court's well aware of the case law defining probable cause and what it is.
Was that just it?
Exigent
The first part we saw at
circumstances,
the
there's
beginning?
also a lot of case law regarding exigent circumstances. The specific cases that the state is relying on are U.S. versus Babcock, State versus Darter.
Oh yeah, that was it. That little part.
The
That was it. All right, I guess.
state has to show for exigent circumstances. The test that's used is an objective one. The factual inquiry is the totality of the circumstances. The exigent circumstance that the state is relying on in this particular case is the destruction of the evidence. Courts have found this exception particularly compelling when you're dealing with digital evidence, and that can be found in the Babcock case. We have detectives who are on scene with the defendant, and at the time that the defendant's cell phone is seized, which is approximately 8 p.m., they had the opportunity to view some of the items in his cell phone. They also knew that Madeline Soto did not report to school. Madeline Soto has been missing for over 24 hours. The defendant was the last individual to have seen Madeline Soto alive or seen her in person. The defendant attempted to destroy evidence already by factory resetting his phone. He did this on the same day as Madeline's disappearance. That's evidenced by the history that is in his phone that he consented to looking at. The
sergeant from the forensics unit testified what it takes to go ahead and factory reset the phone. But he also indicated that when a phone logs into the Google account and the backup starts repopulating, which is what happened in this case, that content will stay on the phone as long as the phone is not syncing with the Google Cloud account. There's evidence and testimony that upon the seizure of the phone, law enforcement officers placed the phone in airplane mode to prevent that syncing. Should the defendant have accessed his Google account and removed multiple items from the Google account, it would not have removed it from that particular cell phone because that cell phone was in airplane mode and was no longer syncing with the Google account.
How did it sync? How did it repopulate? Stop syncing.
When the phone was factory reset and that information corresponding with that Google Cloud account was input upon the starting up of the phone, everything that was backed up on the Google account from that phone began populating on the phone. And that's the 2 a.m. population that Sergeant Sterns mentioned that occurred the early morning hours of February 27th. So prior to these interviews, all of those photos and everything else began to populate on that phone that was in his backup. So when law enforcement saw that there were various items missing and the defendant had already tried to destroy the evidence, it was at that point that they seized the phone, placed it in airplane mode to prevent further destruction of evidence. There was also testimony that even though the defendant factory reset the phone, there was still a possibility through different avenues to ascertain that cell phone's location information and different things. So at that point in time, there was a fear that was objectively reasonable to a reasonable law enforcement officer that would lead that officer to believe that the evidence might be destroyed before a warrant could be secured. That is the standard, probable cause plus exigency. Everything that was known to these law enforcement officers prior to this seizure supports the probable cause finding as well as the exigency finding. They also were aware that the defendant was inconsistent in his statements to law enforcement about where his whereabouts were on February 26th, the day that Madeline Soto went missing, because his initial statements were contradicted by the actual tag reader for his vehicle. His vehicle was seen traveling in the opposite direction of Madeline Soto's school when he indicated that he was driving towards the school and go to McDonald's and dropping her off. There were other inconsistencies that are within those statements that he made, specifically the ones that were provided to the court and are entered into exhibits in
Jules, thank you.
This particular hearing. There are multiple inconsistencies. All of these things lead to probable cause and exigent circumstances for the seizure of that phone. Therefore, the seizure was permitted by the Fourth Amendment in this case, regardless of whether the defendant said, yeah, go ahead, take my phone. The law enforcement officers had the ability to do that. The defense also mentioned place. That case is distinguishable because in that initial detention, that 90-minute detention that they're talking about in there was based upon reasonable suspicion alone. That court then later says that once that dog sniff was done on the luggage and they developed probable cause, that's where they get the 90 minutes from the time that the luggage is detained until they secured probable cause. That's not the standard here because the state's relying on the probable cause plus the exigency to support the seizure. So the place case is actually inapplicable to this case as far as the defense's attempt to have the reasoning support their argument.
Thank you. Brief rebuttal, and then let's move on.
Briefly, while the state argues that there's the two-pronged analysis as to probable cause and the exigency, again, When it comes to the exigency, the direct testimony that was listed during the hearing is that to law enforcement, there is no exigency at the point that this phone is known to have been factory reset, that there is no imminent destruction of evidence because there's no further destruction of evidence. It's already been destroyed. So while we can speculate and guess as to what Tagler and Acasta, the detectives on scene, were thinking as to seizing the phone, what we know for a fact from the Orange County Sheriff's Office is that they know that once a phone's factory reset, it's gone. There's no more imminent destruction. So for the exigency element, I would argue that that makes sense. Moving on to the second motion, if your honor's ready.
Mr. Johnson, I'm ready.
Yes, sir. As to the motion to suppress the unlawful search of the cell phone, again, the burden is flipped to the state. They have the burden of proof to show some kind of exception to the warrant to search of the phone. There's no warrant ever obtained for the actual search of the phone, be it the searches done by Detective Tagler on scene, nor the actual cell phone forensic download. Now, as to the first request by Detective Tagler on scene as to the maps, the statements from Detective Tagler was, "Do you mind if I look at your maps real quick?" At that point, the defendant, Mr. Sterns, had indicated, "Yeah, that's fine." When we look to consent, scope of consent is an essential element when looking to the validity of law enforcement's actions. At this point, there was limited consent to look only to the maps application only, not consent to search the entire phone. As to the second request, as to when Detective Tagler asked, "Do you mind if I just take a picture of your history?" And Mr. Sterns replied, "Yeah, that's fine." Again, this was limited only to taking a photograph of what was already visible on screen, not consent to
I can't
navigating
believe
the
that
rest of the phone
they're trying to
through
get
additional screens
photo
and to access other applications. To the third request from Detective Tagler, if I can go into your settings real quick. I just want to see if you're logged onto your Google. Again, at this point, after pressing Mr. Sterns agrees, but again, this is, limited consent as to merely looking at the settings screen to determine if he's logged into Google. At no point did any of the detectives or any member of law enforcement seek consent from Mr. Sterns to go through the rest of his cell phone, which then we can see Detective Tagler's overstepping the scope of consent when she later indicates, "I was checking your call history. I noticed that you don't have anything before this morning." But when questioned, and as evidenced in the recordings that Your Honor has, there was never any consent sought or given as to checking the search of the call history in this case. So that is completely outside the scope of the searching of the maps, the history photo, or the Google login check. Additionally, when we're looking to consent as to Detective Tagler's request to do an entire forensic download of the phone, this is where defense relies on the Ramirez factors. When looking to the Ramirez factors, the defense looks to Mr. Sterns' freedom to leave. While the state is going to argue that he was free to leave, and the detectives stated that he was free to leave, no statement was ever made to Mr. Sterns that he was able to leave the scene at any time. Instead, what happened is that
Is that required, or is that a factor that you consider?
it's a factor to consider. And
Yep,
when
so many
considering that
factors.
factor, we're also looking to what a reasonable person would feel in that situation. So at this point, Mr. Sterns is being corralled by two detectives by a vehicle. He's not allowed to go back inside of his home. He's not allowed to go inside of his own car. When it comes to the apartment complex, there's law enforcement all around. There's law enforcement at the entrance regulating who's coming and going outside of the apartment complex. It's clear that law enforcement essentially has the scene locked down. And not only do they have the scene locked down, while the state asked whether anybody had drawn firearms or anything of that nature, it was clear from everybody that testified that firearms were readily apparent, visible on scene, which would lead to Mr. Sterns feeling that he was not free to leave. When we're looking to any potential course of police procedures, again, we have a situation where Detective Tagler systematically keeps pushing boundaries of searching Mr. Sterns' phone. First, it's just a check for, hey, can I check the application? Then I want to take a picture of the phone. Then we're going to keep pushing into the settings. And then the detectives push more and more to the point where they start checking other parts of his phone without asking him for his consent.
On the whiskey bet.
So at this point, a reasonable person would believe that, well, law enforcement has my phone in their possession. Law enforcement's going to keep looking through the phone. And while the argument is that he stood there and never said no, it's not the onus. The onus is not on Mr. Sterns to say no. The onus is on law enforcement to ask if they can continue to go through this, because the scope of consent
It's a
is
child,
limited.
and he had 7 million
Detectives
on his.
in the state want to argue
What
that,
is
well, he
argument?
stood right there and never said no, Your Honor. Some 200 years ago, our forefathers said no for him. That said that we have a situation where there's no warrant. Law enforcement has seized his phone. They're searching his phone. The Fourth Amendment says that you cannot do that. The no has already been said for. When we're looking to the ability to refuse consent, additionally, law enforcement never told him that he could refuse to allow them to look through his phone. As to the education and intelligence, when it comes to law enforcement's testimony, they knew that Mr. Sterns was currently in a state of, or this actually goes more towards physical and mental state, that Mr. Sterns was currently in a distraught, stressed out state. They were aware that he was taking medication to try and fall asleep, to take care of himself during these long hours during the course of this investigation.
Jen wanted to like
looking to the
be
actual
all up on him.
physical state of Mr. Sterns, we know it's about 50 to 60 degrees outside. We know it's night. We know the sun has gone down. Law enforcement's with him. We know that he's in flip-flops and khaki pants, and he's not allowed to go back inside his house nor his car. So physical discomfort may have affected his decision-making process. When we look to the standards here again, it's not.
I know it must be hard for someone to represent him.
Mr. Sterns was. It's what would the typical reasonable person have understood what the situation was. And in this case, Your Honor, the defense would argue that as Detective Tagler consistently pushed the bounds, then held onto his phone, just unilaterally seizing it, dismissing his concerns about trying to contact his family, comes back hours later and gives him the Hobson's choice, that ultimatum of
the jury
you can
has
either
to
consent
do all of
or
that.
we can get a warrant. At that point, Mr. Sterns'
I think the judge will
ability
allow it, right?
to
I thought so.
consent has been tainted, it's been coerced, and for that reason, we would argue that all of the searches of the phone violate the Fourth and Article 1 section.
Thank you.
Well, I hope so, because then I'm going to have a problem with the judge. The window is right.
Your Honor, the defense is not arguing that the defendant did not consent to law enforcement looking at his phone. Some of the things that I think are important to point out to the court is that the defendant in this case was free to leave. Both law enforcement officers that were interacting with him were in an open parking lot where he was free to move about. He was in and out of
And they're trying to avoid like the death penalty too.
There was no testimony before, Your Honor, that there was any threats or prohibiting of his movements. The defense argued that Detective Tagler consistently pushed the boundaries. However, Detective Tagler did not push the boundaries of consent in this case. There were multiple things where she was verifying with the defendant his continued consent for her to examine different parts of the phone. The defendant was in possession of his cell phone, unlocked it, and provided it to Detective Tagler. The defendant did not try and retain control over the phone. The defendant did not try and take the phone back from Detective Tagler. The defendant did not try to himself show her various portions of the phone. There was no attempt by the defendant to limit the consent in any way. The scope of the consent is measured by objective reasonableness. What would a reasonable person have understood to be the object of the search during the exchange between that person and
But we're watching the Karen Reed trial. And
you have Detective Tagler, after speaking with the defendant and him
stupid
being inconsistent about timings and locations, she asks him, do you mind if I look at your maps real quick? The defendant confirms. It's at this point he unlocks his phone and hands it to Detective Tagler. Detective Tagler does not walk away with the defendant's phone. They are standing shoulder to shoulder. The defendant can see everything that Detective Tagler's doing. Detective Tagler then says, do you mind if I just take a picture of your history? To which the defendant responds, that's fine. There is no attempt to limit the type of history that Detective Tagler is going to look into. There is this conversation happens. The detective is looking at the
he gets the death penalty by the
time looks at the defendant's call
anything even
history.
happens. Someone would probably.
And there's actually a conversation with the defendant about how Detective Tagler doesn't know how to use the defendant's specific phone. She also asked to go in the settings, and in the audio recording, there is actually a substantial pause before she's finds where the settings are. She actually says, I don't know how to use this phone. Sorry, I didn't mean to interrupt, as he's having a conversation with Detective Acasta as well. There is no time during that encounter that the defendant attempts to withdraw his consent or limit his consent in any way. The defendant does receive the cell phone back from Detective Tagler. There is a portion in the interview where she does say, here you go, to which the defendant responds, thanks. It's a little bit further away from the microphone, so it's a little bit harder to hear, but that conversation does take place before she asks the defendant a second time to unlock the phone. So the defendant does regain possession of the phone. Then she asks to unlock the phone a second time after she steps away. The defendant does so. Again, does not limit the consent in any way. There's actually no conversation at that point about what is going to be looked at. And then she brings up the fact that his call history is not there.
Is this information that she had prior to giving the phone back?
She says, I was checking your call history. I am unclear at what point she looked at it. I believe it's around this encounter, but it could have been before. My position, the state's position is it's during this time frame where she's asking.
The argument of the state was that she asked to take a picture of the history, looks at the call history.
She takes a pic.
Yeah, I don't think anything is ever deleted.
What a reasonable person would understand the interaction is going to be.
I think everything goes to like
is that she uses
data
general
heaven
term history and then she eventually goes into the call history.
And one day,
Is that the first time she's got possession?
That's in the first time that she has possession of the phone. Yes.
At what point in that sequence is the exigency argument, is the state's position that the detective becomes aware of an exigency of the destruction?
It's the second time he hands her the phone because she asks him to unlock the phone. They have a conversation. She brings up that the call log. She said, I also noticed, I was checking your call history. I noticed that you didn't have anything before this morning. Is that unusual on your phone?
And that's
Yeah,
where the
he's
discussion-
ridiculous.
Factory reset.
reset occurs.
Yes.
It's the state's position that on that discussion, that provides the basis for the state's exigency circumstance.
Yes, coupled with everything else that law enforcement knew, yes.
Probable cause.
Yes, yes.
Sorry, I didn't mean to. Misdirect you.
So it's at that point that there's a seizure. There's some other information that's ascertained by law enforcement. And then they do a second interview with Mr. Sterns. The second interview begins at 12:16 a.m. and almost immediately jumps into addressing consent.
I do cover 𝐶𝐿. We are actually been covering it this week, and after this live, we're going to be covering it. Yeah, I'm covering it.
Physically download the phone. It's not very long after their initial introductions on the audio recording.
So we'll do that next one.
She says, I told you I was going to hold on to the phone. We would like to download your phone. Is this something that I have your consent to do, or do I need to get a search warrant for your phone? The state's position is the way that
I didn't cover the first one, but I was there.
It is clear to a reasonable person that the defendant had the opportunity to refuse to consent, because either the defendant can consent, if the defendant does not consent, law enforcement ultimately would seek a search warrant. The defense wants to call that an ultimatum. The state's position is that it is advising the defendant very clearly that he has the ability to object or not allow consent for the forensic download. There's no question that law enforcement
really heavily involved with the Karen Reed case and like the Karen Reed crowd, and then it got to be too much. So when the trial was over, I didn't stop following it. I just didn't play it on my channel. But we're actually
download and to go through the entirety of the phone by the way that conversation is had, because he ultimately answers that question affirmatively, and then she follows up, you're okay with us going through your phone? To which the defendant responds yes, and then he ultimately provides his passcode to the cell phone. Based upon all of the totality of the circumstances and all of the information that law enforcement had and the lack of coercion by law enforcement towards it. In fact, the defendant was actually free to leave and did leave the apartment complex after this second
interview. I don't think that was a violation.
He wasn't allowed to leave in his vehicle because his vehicle was seized, but he and Jennifer Soto left in Jennifer Soto's vehicle.
That's how I feel this case
goes to any coercive nature argued by the defense. The state also
when I deep dive, we mainly
factors,
review like all the court docs.
as
like
permitted by case law.
Entire docket full. I've just
whether or not the defendant was free to leave, whether there was any coercive police procedure, the extent of the defendant's cooperation or his awareness of the right to refuse, whether the defendant could have refused, defendant's education and intelligence, and the defendant's
I think as fast as
intelligence.
I was with you up to extent of cooperation.
Sterns is intelligent.
Or his awareness of his right to refuse, whether the defendant could have refused consent, the defendant's education and intelligence, and
So if you guys are new to my channel and you like the deep dives in the court docs, definitely subscribe and watch, because we cover a lot of docs. I read a lot of documents.
its belief that no incriminating evidence would be found.
Because it's the facts.
All
You know,
of these
cover and we
factors
watch
should be
stuff,
considered
but
by the court in determining the defendant's voluntariness
I like to read all the
of consent. So The state has to show that the consent was voluntary by clear and convincing evidence. And the consent has to be freely and voluntarily given. That is the standard. There was some case law that distinguishes it from a formal waiver of Miranda and things like that, other constitutional rights. The standard
This
for
trial and the Brian
consent
Tagler
is whether it
trial.
was freely and voluntarily. So these factors that we just discussed go to the voluntariness of consent.
This is so loud.
So for the consent that occurs on February 27th, so that first interview where they're actually looking through the phone, the state's position is that consent was valid. The defendant unlocked his phone twice and handed it to Detective Tagler twice. The defendant specifically consented to map data viewing and documenting his history, reviewing settings to see if he's logged into his Google account. The defendant was standing directly next to Detective Tagler as she was viewing the content. There was not the word history was used in the state's position in a general way. It wasn't a limiting way. And they communicate that he was limiting or withdrawing consent. He was free to leave during the conversation. He was not in handcuffs. There was no police coercive tactics. The state's position is the defendant was aware, based upon the questioning, that he had the right to refuse. He could have not unlocked his cell phone.
Yep.
He could have said no. There was
he could have been like,
testimony that
can I get a lawyer before you look
leave,
into my phone?
he could not have consented. They're not in a confined space. And the biggest one is the defendant thought he destroyed all of the evidence. The defendant factory reset his phone twice on the date of Madeline Soto's disappearance. And the reason why he consented is he believed that everything was gone. So the state's position is.
How does he not know that, being like a tech
Essential
person?
search that were conducted in this case.
Get a warrant. Right. It could have been like, get a warrant, or I want my lawyer here while you go through my phone. I don't know. Something, right?
As to the state's argument that looking to Mr. Sterns' belief that he was free to leave, again, this isn't on law enforcement's observations. It's based on what a reasonable person would believe in that situation.
He wasn't in
Here,
handcuffs.
well, we don't have
I don't know why it froze. Hold on, I'm trying to fix it. Oh, wait, it ends there?
All right, so you've been listening to and watching this suppression hearing in Osceola County. It appears we just lost our feed as those arguments.
Oh. Yeah, they lost the feed. I saw that on Grizzly's channel too, that they cut the feed off. That sucks. But wait, we didn't even get to hear if so do they grant it or not? Like, what does he say about suppressing the information? I'm trying to pull something else up to see if we can get some answers. That's crazy. Here, let me pull this up real quick just to see if they say anything about it. Oh no, that's just do they have to have another hearing to let us know what they decide? Let me pull up this video real quick. It's by the same channel we were just watching. Hopefully it's a little better.
look at the Stephan Sterns trial that we know has been pushed back as a judge weighs a decision on the evidence. We talked about this yesterday because of that suppression hearing where the judge is going to be considering whether or not to allow evidence specifically concerning from the cell phone of Stephan Sterns. This is in the sexual battery case that was originally slated to go to trial May 5th, that is now scheduled to go to trial in July. So a lot of interesting things in court yesterday, and as this case kind of moves forward, joining us live now via Zoom to talk about this is Lauren Cadillac, who is an attorney, the owner of Cadillac Law in Dallas, and
we get the answer. Give me one sec. Sorry, I didn't know that stream cut it off, but this is where it got denied. Yay! We're happy about that. Let's watch this and then we'll move on to Karen.
We're on the record. State of Florida versus Stephen Michael Sterns, 2024 CF 632. Appearances for the record, please.
Danielle Pennell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Sterns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m.
Wow.
Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has case law provided a copy to the state already.
Wait, did we already watch this part?
You want me to give you a moment to read, Judge, or you want me?
Just a moment.
Yuck.
These highlight the McKay factors.
Essentially, Judge, they all essentially stand for the same
Okay with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State and Second 1280 from 1987, Southern Second 129, 50 CA from 2004, and Singer versus State 286, efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion as well.
Because the sex crimes is one trial, one case, and then the murder is another.
That at this time, the defense is in a position to be able to divulge to the court
That's why she says
or in
that.
open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice into the homicide case.
That's true.
Defense would argue that
one will taint the
this
other.
Information has come to light recently, and we're still in the process of working through it and figuring out if it's
There'll be a
something
PDF
that
file.
wouldn't be available in
Or
this
murder.
case if the defense were to go forward with the
Well,
motion
how
to
about both?
suppress at this point. Potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would be moving to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We weren't able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing both from factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court and filing the motion and getting this set for a hearing and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
Right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor.
The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, a little 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge. Defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense would be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed. Discovery exhibits haven't been disclosed in regards to it because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions. So I spoke with the state in person about it, and then sent her an email in regards to her position. And then from there, filed the motion to continue. And then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there's been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March, 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming, are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of a good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
Anyways, crazy. We'll definitely keep up on this. Make sure you subscribe. I'll be covering more of the Maddie Soto case on my channel. That was just the hearing. Thank you for being here. Make sure you hit the like button on the way out, and make sure you turn your notifications on. We have another live coming up after this one. So again, thank you for being here, and I will see you on the next one. Bye.